backdrop and all that, but no cell phone use whatsoever today. Okay.
It's a little better. It got better when you moved the other ones. The far one, no, the one in the front. Right.
All right, good morning, everyone, and welcome to Uncivil Laws. We watch yet another hearing in the ongoing Karen Read case, in the continuing Karen Read Stupid. Not quite sure which hearing this is, to be honest, but we're going to see what's happening in the ongoing Karen Read Stupid, because there is, of course, as always, so much stupid when it comes to Karen Read.
Thank you. Thank you. That sounds fine now. When he moved it, it adjusted it got rid of the hum.
The hearing is supposed to start here in just a couple minutes.
Yeah.
So we will see what's happening. Law and Crime, unfortunately, has no description of what this hearing is. Simply saying it's a hearing. That's somewhat annoying. Miscellaneous motions hearing, I guess. We'll see what we've got. Who's Karen Read? Karen Read is a woman who is accused of killing her boyfriend by backing up over him in Massachusetts. House Long to Die girl. There was a mistrial last year, and she's currently scheduled to be put on trial for the murder manslaughter this year as well. The case we've been following.
Sullivan?
It is a little early. Good morning. Thank you, Patius, for becoming an uncivilian. She's not the House Long to Die girl. That lovely woman is Jennifer McCabe. Jennifer McCabe is definitely sus, and more sus than Karen Read, at least in my humble opinion. Well, it'd be hard not to be more sus, because I'm pretty sure there's no evidence against Karen Read, so yeah. Yeah, we watched her first trial. She didn't do it. The whole thing is a farce. But the state has a boner out for this woman for some reason, despite the fact the evidence doesn't exist that she did it. What was the indictment based on? Lies, to be quite honest. We found pieces of her taillight, except we totally didn't. Except then we totally did. How many pieces of your taillight did we find? Oh, we found none. Oh, we found 6. Oh, we found 5. Oh, we found 9. Oh, we found 42. Yeah, like lies, basically. That's what the indictment was based on, lies. The whole trial was messed up. We've got lots of videos of Karen Read from the first trial over on the channel. So we've already done 30 videos or something on this woman and her trial because the case was so fucked up. It was a laugh. The state crime lab used solo cups. Exciting. They didn't have logs for the crime lab. They didn't label things. The timeline doesn't really work. None of it really makes any sense. You think she's going to be found guilty? Well, that would be a travesty of justice if she is. She wasn't found guilty the first time, and hopefully she won't be the second time.
Had a whole thing.
Oh, hey, David.
Yeah, I've got it. No, I have not found your motion.
Good, how are you?
Yeah, well, and also there's a possibility that the jurors wanted to acquit her on murder, leaving the scene of an accident, but didn't feel like they could have because of the particular instructions, which is an issue that's currently on appeal to the Supreme Court of the state. $10 from Fadius Padius. I work in digital forensics for a few federal agencies, and the idea that Richard Green isn't qualified is insane. It's insane that Bev has even entertained the motion. There's a lot that's there's a lot that is pretty insane about this, to be quite honest. The twice or thrice board certified ER doctor with 40 years experience, we weren't quite sure whether or not she was qualified. Fortunately, we determined she was.
Yes.
But we had to have a hearing on it.
This is one. So we have 1 and 2
Defense.
so far. So
Okay.
All right, I need to go get my coffee.
Laura's bringing it, and then
It's done being made, so I have to go actually get it. Give me 1 second. I'll be right back.
reports attached to the motion. Should I give you separate copies for exhibits?
Okay. Yeah. Okay. I just couldn't find it. She's gonna see if she can find the actual motion. I remember an email, and I remember us having it.
Which motion do you need?
The concerning the clarification. Okay. Which is a search warrant. I just didn't see it. It's not the first thing to make your project. Yeah.
What is it, just congestion? The folks that just showed up, please, no cell phone use whatsoever, even during sidebars and breaks. I don't want to see a cell phone out at all. No cell phones.
Because I just brought the attorney downstairs. Thank you, thank you. I'll be with you. Yes. Up to me. It's up to me, by the way.
They drove overnight. Look, I was at the second stage.
This is a very,
What's going on?
this is a very famous scene. You want to hear that story?
Still a lot of
The judge came out one time, and Eddie Sheehan, one clerk, stood
on the
up,
highway.
pants went right down to the ground. And the judge turned around, and the clerk said, "Show's over." I saw it. I was like,
Brendan and I exhibits that the contest, so
that was great for you. Well, you know what?
step, and then he hears the new terms. So Brendan and I agree to, then she's got them already.
But if he comes back in 10 minutes,
You know what?
maybe you guys can handle it. Probably not.
But I said,
Oh, they could get well for you.
and I said, well, Brendan and I agree to taking all the views, so you just give them to the judge and start to say what he wants.
Oh, thank you. Who's better than you? I thought he was going to do it for me.
They're always back, and we want to make sure it's not just 98%. Yeah.
You're a gentleman.
Opposition.
and then they'll comment on it.
Okay, that's it.
Your bar is
Yeah,
printing you right.
they're coming in now.
That's right. That's right.
Thank
That's
you.
right. That's right.
The bar is printing you a copy right now.
Okay, got it. Got it.
I think I should put everybody on.
Got it. Okay.
Got it?
Thank you.
Okay, yeah, of course.
Mr. Lally, how are you, sir?
Yeah, it was great. Yeah.
Coffee is made. Excellent.
What's that? I'm good. What's that?
Has anybody checked to make sure the mics are not on at our table with the TV people?
Just a reminder, folks, about cell phones, please. Make sure that on their silent modes, please, all cell phones, please.
That boss?
It's under the table,
That's okay. Thank you.
Exciting, enthralling so far this morning. Yeah, the first trial, like, I can't believe the jury was even hung. I don't know what they were debating. I mean, to me, it was so cleanly not guilty. It was so absurdly not guilty. Based on the evidence presented, which there basically is none, and the evidence that was presented was corrupt, completely deficient.
I'm gonna pop first this morning if you're okay with that.
Oh, yeah. These are small.
You're not sure you can watch this trial fail uphill again? I understand.
Did you guys?
Why we're in court today for miscellaneous motion hearings. Not quite sure what motions are on the docket today.
Your motion, you're gonna go first.
Miscellaneous motion hearings. Court TV did not, or Law and Crime did not specify in their description what we're here for today either. So I'm not quite sure what motions we're here for. Didn't they have a cop on the jury? I believe, yes. Yeah. Motion for a Doe-Bear hearing for Green. The state loves their Doe-Bear hearings now. They want to make sure all these witnesses are really super qualified, and they really want to drag this through they want to really drag it through the coals, man. It's like they're making the defense really work for it. Are your experts really qualified? It'd be like, have you seen Trooper Paul? How dare you ask us that question, man? I mean, come on. I saw the black boxes. Both of them apparently have been recovered relating to the air crash in D.C. I was watching a press conference in which Nancy Kerrigan was speaking. It's like, that's a name I haven't heard from a while, right? That's a name we haven't heard for a while. So that was interesting.
You are unmuted.
I was thinking about maybe covering the Kash Patel hearing today, at least some of it, for the FBI director. I was thinking about maybe covering that today. I don't know. I was like, what do I do with my day now? Because the last 2 days I've been covering these nomination hearings, and there are no nomination hearings today. Very sad. Did you know a helicopter could possibly crash into an airplane? Well, sure. I mean, why not? I mean, in principle, why? Yeah. How that was allowed to occur is much more the interesting problem. My bet right now is on the helicopter pilot fucking up. Based on the information that's available, it seems like the helicopter pilot was at too high an altitude. By like if I'm understanding the data correctly, he was supposed to be flying at no higher than 200 feet, but he was actually flying at about 350 feet. at the time of the accident, and he had twice been asked by air traffic control whether or not he had visual confirmation of the plane, and said yes. And it seems like he was looking at the wrong plane. It looks like he was looking at the plane behind the plane and didn't see the plane in front. But he twice said that he had confirmation of it. And so it seems like it was the military pilot who fucked up based on the available information. I'm going to an all-you-can-eat sushi bar. Very cool. All-you-can-eat sushi can be fun. Have fun. Get a California roll for me. Right now, I've got my morning coffee. I'm going with a blend to turn it into about 500 calories worth of. Let's see, because it'd be about 550 calorie breakfast. So that's what I'm going to have for breakfast. 2 scoops of protein powder and some butter. Unsalted, of course. Got yourself a little bulletproof coffee. Nice way to start the morning. How the conspiracy framing thing turn out with this case? In my humble opinion, quite well. I think that they definitely were trying to pin it on the girl. How much malice is involved in that is unclear, but they were definitely trying to pin it on the girl. You should try a battery-powered coffee cup. Keeps it wonderfully hot, but I don't like my coffee hot. I actually put ice in it so that it cools it down. I like my coffee fresh, but not hot. Iced coffee. The Black Hawk pilot asked twice for request visual separation. Yeah, why not have ATC say Pat 25 visual heading X? Yeah, maybe the ATC could have given more information. Maybe there's some more information to be given, but I still feel like on balance it's on the military high. I feel like on the helo. You know, he's the one flying the helicopter. He is, responsible for that. I went to an all-you-can-eat sushi bar where they make for you as you asked, but after a while they did something weird to taint the flavor, like salty weird rice. Interesting. Crumbly hearing is on now too. That was my understanding. And Crumbly was also on. I had to pick one or the other. Maybe at the end of this stream we'll do the Crumbly hearing. We'll do a new stream and we'll pick up the Crumbly hearing. Or at least that way we can skip through the boring parts for the Crumbly hearing. Sushi's pretty good. I mean, I haven't had sushi in a while. Last sushi I had wasn't really great, though. So. The helicopter really had no excuse for being the set lane of traffic for airplanes. I think there's some people to be laid on, blame to be laid on the people who planned the exercise.
Just because it moves.
Yeah. It looks like the helicopter was in the wrong place, man.
We may not be that.
Maximum height of 200 feet, and it was at 350. That's a pretty big fuck up, man.
Admitted as exhibits in the file, just in case you want it separately. Thank you.
Not that I'm necessarily comfortable with a helicopter being within 150 feet of a flying commercial jet, but still, they would have not hit each other. So, which is presumably why those limits are there in the first place, right? Like, just in case, somehow everything else fucks up. If you're under this limit, you won't hit the plane. But it was in excess of the limit. They're waiting for the judge. Judge late. Although, as they say, a judge is never late. They arrive precisely when they mean to. So, yeah. One bonus to being sick all week is when you wake up better but starving. Best kielbasa is half-starving kielbasa. Sounds promising. Judges are like wizards. They even have the robes. A little bit.
All rise to the court, please. Hear. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, in the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Jesus Christ. I mean, that accent is so thick. It's like, are we in Massachusetts? Are we in Boston? I don't know, man. I'm not sure. Could you give me that cry again? Holy God.
Good morning, Your Honor. Hank Brennan for...
Good morning, Mr. Jackson.
Good morning, Your Honor. Robert Alessi.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Oh. Good morning, Mr. Birchie. Okay, let's see. So we've got several matters for this morning that I want to discuss. So first, there's filed a motion to recover expert-related expenses from the Commonwealth, and we'll discuss that in some manner at the end of the hearing today. We've also got Mr. Birch is here on Ms. Voss's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCA. And the last one is the Commonwealth's motion to exclude witness Richard Green's debunked opinions. So those are really in that order.
Yeah, the court audio is out of
I think
sync.
we should start with
That's exciting.
the non-party Gretchen Voss's motion to reconsider regarding the notes.
Maybe if I refresh the stream, maybe it will stop being out of sync.
A motion to file.
Probably not, but we'll give it a shot.
amicus memo. The signatory is Mr. Albano. I've received that. I will allow that to be filed, and I've read the motion and the memorandum. So I will hear you, Mr. Birchie.
Good morning, Your Honor. Rob Birchie for Gretchen Voss. I'd like to start by just thanking the court for taking the time and giving me the
Lawyer Wilford Brimley apparently has showed up this morning.
That ruling allowed in full the Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss or Metro Court. Ms. Voss and Metro Court complied with the court's order for production of documents on January 2nd by producing to the court all of the responsive materials, the unredacted tapes and the text messages that involved on-the-record communications by Voss with defendant Reed. I'm here today to implore the court to reconsider that part of its ruling, but also would require Gretchen Voss to turn over handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record. What's in those notes is really a black box. The Commonwealth has provided no information indicating what it believes the notes will reveal, or why it has particular reason to delve into them. So the question before the court is whether the Commonwealth should be entitled to forage through this reporter's notes and compel her to break her promise of confidentiality with the source in the ungrounded hope of finding relevant and material evidence somewhere in those notes that will aid in a prosecution of the defendants. The stakes for Gretchen Voss are considerable. As she set out in her second affidavit submitted to the court with our motion for reconsideration, her effectiveness as an investigative reporter depends upon her having the ability to use the tools of the journalism trade, and among them is the opportunity to reliably assure her sources that certain information...
We gotta give some of these lawyers like a little bit more public speaking classes. I mean,
stakes are high as well, because the Commonwealth
it's so
is
dry.
asking the court to give no weight whatsoever to the off-the-record nature of the notes, and that is what renders a journalist's promise of confidentiality illusory. Off-the-record is a phrase you hear in virtually every conversation between a reporter and a source. Frequently, it's an interjection in the course of a sentence. This is off the record. The kind of lubricant that allows a source to have a free and full exchange with the reporter without having to guard every word they speak. And receiving information off the record is often a technique by a reporter to establish trust and rapport with a source. That source might be a whistleblower, might be a frightened migrant, or might, like Reed, be a criminal suspect. On page 2 of our motion for reconsideration, we quote from Primer on Journalism that says, off-the-record interviews...
What is he reading?
In building trust between journalists and their sources.
Is he just reading his motion verbatim?
That can provide context or background.
Or did he write out a speech?
Disclosure. The result, it says, is to enhance the depth of the reporting and provide leads for other sources. In Ms. Voss's case, she states in her second affidavit,
If he's reading out his motion verbatim, I'm going to come up there, I'm going to slap him in the face.
Information from sources off the record is a normal and critical part of my work. Like most investigative reporters, I frequently agree with sources, including named sources, to keep certain of their statements or interviews off the record, not to be published anywhere. Keeping my word on this is critical to maintaining credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public. The court's December 5 order forces Gretchen Voss to choose between either keeping her word to her source and thereby violating the court's
I tell you what, man. I tell you what, I have tuned out to anything this guy was saying long ago.
Cannot be trusted.
It is not good presentation.
Necessary choice to present to her, at least on the facts of this case.
I'm sorry, something journalist privilege what?
On publication of the off-the-record
Oh, privilege?
because the Commonwealth has failed to meet its burden under Rule 17 to show that mandated production of the records on the facts of this case would not be unreasonable or oppressive. And also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant.
I swear as a judge I'd be interrupting him. I'd be like, what the fuck are you reading from?
It's very clear.
That's what I want to know right now. What are you reading?
The First Circuit wrote that Bruno and Stillman.
If you're reading your motion, you can just stop now. Thank you.
Is one that demands sensitivity, invites flexibility, and defies formula. While obviously the discretion of the trial judge has wide scope, it is a discretion informed by an awareness of First Amendment values and the precedential effect which decision in any one case would be likely to have. And in Re Cusimano in 1998, First Circuit said, that was a case like
This is neither defense nor prosecution. I believe this is a lawyer for the reporter because they're trying to get information from a reporter. So I believe he is
Cusimano, they said, when a subpoena
the lawyer for the
seeks
reporter.
divulgement of confidential information compiled
And
by
I want to
journalists
gouge out my
in anticipation
eyeballs.
of publication, courts must apply a balancing test. This test contemplates consideration of a myriad of factors, often uniquely drawn out from the factual circumstances of the particular case. Now, as I noted in the December 5 order, the court drew no distinction between the on-the-record and off-the-record interviews. When it applied the Massachusetts balancing
I
test,
can't
it
be
mandated
bothered to care about anything he's arguing about.
and audio text.
I want to rule against him just to get him to stop talking.
This confidentiality promise as a factor in the equation. That, we submitted, was critical oversight. Because whether you call it a privilege or not under Massachusetts law, Massachusetts does recognize that there is
You know you're having a bad day when I'm like, you know what? I'm less interested in what the law is, and I'm more interested in you shutting your face.
for the discovery of materials. Note it says materials, not source identities.
Put down the paper
Courts face
and say what's in your heart.
for the discovery
And try to say it with some feeling this time. Holy shit.
Courts should be aware of the possibility that the unlimited or unthinking allowance of such requests will impinge upon First Amendment rights. In determining what, if any, limits should accordingly be placed upon the granting of such requests, courts must balance the potential harm to the free flow of information that might result against the asserted need for the requested information. So, what are the factors that the court should look at when conducting an analysis under Rule 17 and under the balancing test? Taking Rule 17 first, set out in the LaRouche case, they cite the Nixon
Yeah,
case,
I definitely, as a judge, be like, please stop talking.
production prior to trial.
I would definitely be like, please stop talking. Is your motion on paper?
Number one, that the
Unbreaded?
documents are evidentiary and relevant.
Great.
Number
Thanks.
two, that they're not otherwise
Good.
procurable
Please sit down.
reasonably in advance
Thank you.
of
Bye.
the exercise of due diligence.
I'll read the papers. Please stop talking.
Properly
If I
protect
promise to read your motion, will you shut up?
inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And number four, that the application is made in good faith and, critically, is not intended as a general fishing expedition. In short, the court was explaining that the special prosecutor in Nixon was required to clear three hurdles: relevancy, admissibility, and specificity. And the court held in Nixon that there was a sufficient likelihood that the tapes contained conversations relevant to the offenses charged, and sufficient preliminary showing that the subpoenaed tapes contained admissible evidence. In this case, however, there's been no showing that the handwritten notes contain
Citing
information
Nixon?
relevant to the offenses charged, and no showing that the handwritten notes contain admissible evidence.
What?
When you apply it to the facts of this case, there is uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know whether they're relevant or not. But there's no specificity whatsoever in the form of a preliminary showing by the Commonwealth that the notes contain admissible evidence. Compare that to the materials the court ordered disclosed. The court found that there were indications in the redacted audio tapes that when unredacted, the tapes would contain relevant and admissible evidence. That's on page 5 of the court's order.
Stop whining, Kurt. We get it. I don't know if you know this, but this is a legal commentary channel, so I'll comment as much as I want when the thoughts go through my head. Thank you for being here.
Would be anything more than a fishing expedition. To the contrary, the fact that nothing from that interview that resulted in the handwritten notes, nothing from that interview was used in the story, and that would suggest that the interview did not contain significant relevant information. As to the balancing test and the First Amendment interests, here too, the December 5 order ignores the on-the-record, off-the-record distinction. That distinction matters. Confidential information is extra protection because, as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information and therefore would have a chilling effect on speech. The court in LaRouche identified First Amendment interests that militate against disclosure of confidential information. One was the threat of judicial intrusion into the news-gathering process. Another was the disadvantage of a journalist appearing to be a research tool for the government. Number 3 was the resulting disincentive to keep outtakes, or in our case, keep notes. And number 4, the burden on journalists' time and records and resources in responding to subpoenas. And if you look, Your Honor, at the affidavit of Chris Vogel that was submitted with our original opposition, he talks about each of those factors in his affidavit from paragraphs 13 through 18. He says he worries that compelled disclosure may lead to a public perception that Mrs. Voss is taking sides in this case or is acting as an investigative arm for the judiciary. Trust in the news media is already fragile because reporters compile information for a living. There will always be attractive targets of discovery for one side or the other. The unrestrained use of subpoenas to compel testimony or documents from reporters.
New donation from William Thompson.
Thanks, William, for the donation. Appreciated. You the man.
Government or the defense. The Fourth Estate can only serve its role as a pillar of democracy if it has the public's trust. Second concern that editor Chris Vogel pointed out in his affidavit is that another risk of compelled disclosure is that it becomes easy, if it becomes easy or routine to subpoena journalists to hand over their interview notes, the legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media. A third factor that was concerning him was that easy allowance of media subpoenas.
You're citing some sort of secondary authority, right? He's reading some guy's paper on like why this is bad. This doesn't really make sense to me. His argument doesn't really make sense to me. The journalist protection, to the extent that it exists, is a creature of state law. His citations to the First Amendment are off point. The federal law does not protect journalists in terms of their sources as a matter of law. You know, the DOJ has internal procedures, but once they issue the subpoena, like, you can't stop it, right? And so, like, his citations to the First Amendment are off point. His citation to the federal case law is off point. His citation to this secondary authority is off point. What you'd want to do is you'd want to quote from Massachusetts decisions, or maybe decisions from other state courts that also have some sort of comparable journalistic privilege, right? You want to make the argument based on the precedent in the statute, and he's making a very high-level philosophical argument.
And they're documenting interviews.
It seems off point.
Whereas they will be if their work may become the subject of public.
You know, we're not trying to determine whether or not journalistic privilege is good. We're not talking to a legislature and hey, legislative branch, here's why we should have journalistic privilege. Here's why it's a good thing. Let me quote from this guy who tells you why it's a good thing. He's in court. I mean, what? I don't get it.
Risks putting it again in the limelight.
Oh God, the stream paused. Oh no, it's back.
Mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that shows that she was dedicated to covering the trial, come what may. She tells me she has, in the recent past, gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted her personal telephone number
Check 1, 2.
for everyone. And the commenter to that post suggested I'll call her right away. And she's received several strange phone calls since that time. Because of the disproportionate harm to First Amendment and Article 16 interests caused by production of the confidential interview notes, we ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
All right. Thank you very much.
Oh, good. It's over. Thank God.
I do have one point to make to you, Mr. Birch. In the amicus brief, or the memo that was filed this morning, I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your argument suggests that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over. So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the defendant.
Right. It's the words. Right,
So
not
I'm
her
gonna
thoughts
give you
about
the
those words. We don't care what the reporter thinks.
Redactions to me.
We care about what the defendant said.
I have the notes.
Okay, I get it.
And you can propose redactions to things that are not reflective of communication with the defendant. Observations, things of that nature.
Well, Ronna, there's nothing in the interview notes that is reflected in the story except architectural details, that there's a rosary on the bureau, or the wall is blue, or whatever it might be. And I went through the notes with this question in mind. Can you separate the impressions, integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case. She shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else. There's no reason for the Commonwealth to be going after Gretchen Voss as a reporter for this, other than the fact that she's a reporter and she's done the investigative work already that presumably the Commonwealth has already done.
Okay.
Thank you.
Thank you. Commonwealth?
Your Honor, I'll simply say we defer to the court's judgment and whatever limitations the court imposes. I have no further argument.
Okay.
The Commonwealth knows that they're about to win,
Thank you.
so they shut their face. See, that's being a good lawyer, because the judge just said, I'm inclined to give the Commonwealth these things. And the Commonwealth, like, oh, I'm winning. I'm going to stop talking.
Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. And I know from when we were last in court, the Commonwealth was perhaps having conversations with the federal people to see if you could get anywhere with this. Is there anything I need to know in that regard? And if we need to do it at sidebar, we can do it at sidebar.
I don't think there's a need, Your Honor.
Okay.
Although it's not incumbent on the Commonwealth to pursue Rule 14 discovery of a party that's going to proffer an expert, Commonwealth made best efforts anyways. I filed a TUI letter, and I was unexpectedly not disappointed when I received a response last night. It's insufficient, it's inadequate, so the issue of pursuing Rule 14 discovery through the proponent of the expert, that being the defense in this case, is something that is a matter we're going to have to address.
Okay.
I did speak to the defense this morning. Since the TUI letter came last night, they have, I don't want to speak for them, but have asked if we would consider some time so they can respond. I am content if it gets deferred until the next date, but it is an argument that needs to be made.
Okay, who's arguing now for the defendant?
Good morning, Your Honor.
Morning.
I agree with Mr. Bennett's recitation of our conversation this morning. If it pleases the court, we did get that TUI letter. I was copied in on that letter late last night. Reviewed it last night. I think that it'll be incumbent for me to at least analyze that letter in a little bit more detail and utilize that letter in my response to the Rule 14 argument. So if we could have another date.
Sure. Well, we have next week, Thursday and Friday scheduled.
That's what I was thinking.
We'll do this next week and come up with proposals on how we can certainly not violate anything that the federal court has said we can't do, but ways that we can go about it.
We'll be mindful.
All right. So if you can work on that, I'd appreciate that. So I will take.
Can I
the
boost
lead
court
from
audio?
the
Nope,
two
I
of you on
can't.
Thank you.
that. Okay.
Court audio is already maxed out.
So
You know,
this brings
welcome to
us
courts and welcome to where different mics are.
The Commonwealth's motion to exclude defense witness Richard Green's debunked opinions.
Well,
So I have
what a
received,
spicy motion title.
A great deal of pleadings on this. So the Commonwealth's motion, and there was a affidavit attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance, so I'm a little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
May it please the court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long to die in the cold at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. This case, I propose, on behalf of the Commonwealth, is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify and answer questions about his affidavit and his opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. If this case, as the court proposed, potentially scheduled for next week, Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. My suggestion is there should be 2 witnesses, Mr. Green and one witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Green, I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology. Mr. Green has filed 2 affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional knows what they do for a profession. Simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9. He talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, and insinuations, and surmise, and conjecture, and claims that have no factual basis. But there is little on methodology. In ways, it is a very dangerous affidavit to simply...
I think this argument's pretty fucking stupid. How about that, Pond? Walden, I think this argument's pretty fucking stupid.
Very important. Die in the cold without any forensic data.
He seems pretty well qualified to me. I'm sorry you don't like his opinions, but you know, get your own expert, come up with different opinions, I guess.
Never proving, never providing fact that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened.
That's why you wait a second. Whoa. What bullshit did you just say? I'm sorry.
Tampering with evidence. In fact, replete with accusations. Similarly, when we look at his affidavit, it is replete with accusations suggesting but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened.
What? No. That doesn't make sense. No. No. He's the one who's establishing the proof. We're trying to establish the proof. That's his job, right? He's like, oh, I think that there's tampering. I think that there's manipulation. I think that's his opinion. And you're like, he shouldn't be even looking into it unless there's proof of it in the first place. Where would that proof come from? Right? It's like, where would the proof come from for him to... He is the guy who looks into it and he looks at the data and says, oh, I think there's been manipulation. I think there's been whatever. That argument doesn't make any sense to me. I don't get that argument. That argument's, I don't get it.
Well, when we look through his entire affidavit, we don't see any attachment of raw data. We don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense...
It's not speculative. It's a conclusion from an expert. Do you know how expert witness works? Do you know how an expert witness works? Do you understand how an expert witness works? Okay.
without having an opportunity for Mr. Green prior to trial stand behind these statements under oath. We'd like him simply to come before the jury, make these salacious comments,
Salacious.
and then leave it to the government to knock it down. And that might be a common viewing the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government's going to take to this case.
I think it is the approach you're going to take because that's your job.
Have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there's some type of race that Mr. Green looked at or used more tools than a Commonwealth expert. The tool is simply software. A good analogy is that of an X-ray. Anybody can take an X-ray, but it takes an expert then to interpret the X-ray, to interpret the data.
Okay.
In this case, Mr. Green, in his affidavit, proposes that because he used a number of tools.
Also, I would like to question the fact that anyone can take an X-ray. I think you probably have to have some kind of training. I'm not sure necessarily you want Uncivil to take your X-ray. I don't know what to do. Probably won't end well for you. Yeah, I'm not so sure about that one. Okay.
He has a number of X-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that. He cites two opinions. His first opinion is based on Cellbrite processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is stepped aside from...
Also, I probably, like, on balance, would feel like if you asked me, like, as an untrained person, on balance, would I feel more comfortable performing an X-ray or reading an X-ray? On balance, I think I'd probably feel a little bit more comfortable reading the X-ray. That bone broke. Right. I mean, the bone's supposed to be solid, bone not solid. You know, I probably, yeah, I mean, I feel a little bit more comfortable, you know, that's a problem. I feel a little bit more comfortable reading the X-ray as an untrained civilian, to be honest.
Methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support of Cellbrite he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engage in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason, and I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance of Cellbrite, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom. Axiom, the government, the defense touts, is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. And that gets back to the X-ray analogy. He is viewing data from many different programs that say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that the Axiom user manual describing the artifact as follows, that the artifact is in Safari suspended state tabs, and then it has the last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, you don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes, in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to, and this is the death knell, really, for the analogy that the defense tries to make. The Safari suspended tabs contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the artifact may contain an earlier date and time compared to the results in the Safari history artifact if multiple devices on one iCloud account. And so, by Axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual search. And this has been presented to the court.
That sounds a lot like something another expert could testify to me. You know, it's like, okay, this thing doesn't reflect what you think it does. There's another reason it could be. And if the manufacturer says, here's a reason that this could be true, right? And then it's like an expert could say that, and then the experts could disagree, as one does. And you could cross-examine the expert about this information from the manufacturer. Maybe they have an answer and maybe they don't. Maybe their answer is the manufacturer's full of shit. They're lying and this is bullshit or whatever. I don't know, but you're just talking about a battle of the experts. I don't think that you can state this like as a matter of law, which is what you're trying to do, right? As a matter of law, this must mean this because the manufacturer says so. I don't. That argument doesn't really work for me.
We've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be open. It is open at a particular time. And if that tab is reused, the original time will imprint. And so, certainly Mr. Deline knows of the Commonwealth's argument. He knows of the opinions by Mr. Whiffen and Ms. Hyde because he
okay.
shots at them. Or
So their expert thinks that your experts are full of shit.
he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side. When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear.
Shut your face.
There are two opinions that are proposed pursuant to this affidavit. The first is the claim that How Long to Die in the Cold was somehow inputted at 2:27. The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen and Mr. Green. But a simple understanding, wall file can contain information as a repository. And the description or misunderstanding by Mr. Green of the wall file is clear in his affidavit. In fact, he implies that there were 3 searches in his affidavit, number 16. Let's look at this phone, that there were 2. Surprised that his second opinion is an attempt, really, just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because, number one, doesn't have any resonance. Anything somewhere, somehow. Not an uncommon.
The start and stop of the feed is really also making my day just a lot better, I'd have to say. As a streamer, it's making me super happy. Their feed just keeps starting and stopping. That makes it real easy to follow.
Manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness,
He disagrees. He thinks there is a factual basis. He looked at the data, and that's the conclusion he came to.
basis, we should not trust, without vetting that witness, that their other claims have any merit or value. In opinion number 2, this expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehashed after manipulation with the PDF being modified. Wow. An extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It is because the claims he makes in opinion number 1 are so scientifically and forensically unsound. This is a tactic to confuse the issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when you don't have any facts.
He does have the facts. He has the data. He has the thing. Now you say it isn't what it purports to be, but he does have a fact. He has this entry in this thing, and he's like, this is what that means. Now you're like, that isn't what that means, but that sounds like a battle of experts. But he does have a factual basis. He's not just making it up. And he's like, well, I've been doing this for a long time, and I use these tools, and these various tools told me this, and this is what I think it means. And like, yeah, I mean, you know, I don't. Okay.
Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact in data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. when you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation, because it didn't happen, he turns to police manipulation. And he says that there can be a problem where the hashes don't match, but the problem is the hashes do. They match. He complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then sprints out into a different universe and suggests that somehow it must be because there's manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, the gray key file, and the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic. The problem was expert witnesses went through that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall.
Thank you, Nikki Lewis, for being a member for 22 months.
Or uncertainty or merit some conspiracy. He lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a difference of opinion. I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain through the court why he did not engage in methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims. The Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is
I'm not sure I can listen to this guy's voice for 6
appropriate in
weeks.
this case. When we look at the different non-binding factors of Lanigan, we look at
It's
number one,
already becoming
whether
trying.
it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology. Number two, the opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffin's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no testing that his opinions have been subjected to. There is no peer review. There is no other alternative support for his opinions. They're just broad, baseless claims. Number three, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to anything.
How would you even do that in principle with respect to the particular case? Every case and where an expert testifies now has to be peer reviewed? That would slow things way down.
Hyde and
Yeah.
it's just a high level of error. It's gross error. It's total error. It's wrong. And is governed by recognized standards.
Oh, thank you, Anne. That's very kind of you.
You look at the
Oh, thank you. That makes me feel good about my day.
attachment. It talks about
You get an uncivil smile.
obligations to verify, to test. Things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom or the guidance that they give him. He sidesteps both of them to give the opinion he wants to advocate for the defense. At every turn, the positions of Mr. Green are not only unsupported, they're unverified. And so what arises from this subterfuge is that Mr. Green is really just a vessel, or an attempted vessel for the defense.
I swear, I don't know what it is exactly about his voice. I can't exactly put my finger on it. But I didn't really object to it at first. It's only been as it's been ongoing. So, like, at first I thought it was fine. Some voices you hear and you're like, no, I'm out, right? You have those things. But this has only been like as it's been ongoing. Right? Like for Wilford Brimley lawyer. Right? I was like, no, this is no. I was like pretty much out, like basically right away. This guy, I don't know exactly what it is. Is it that he has a fry in his voice, or but it's getting really, really trying. I don't know that I can do this for 6 weeks. I don't know that I can do this for 6 weeks. I may lose my mind.
Party culprit defense. It is not lost on me, I'm not unmindful of the data on the phone being a search how long Diane Cole that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking.
I'll take Lally over this guy.
That time about Mr. O'Keefe.
I made it through the trial with Lally. I'll take Lally.
Under the extraordinary broadness of circumstances, in the depth of the amount of witnesses and information in this case, it is hard to think that that just happened by happenstance. That there is a inquiry, something forming in the mind of the accused, is then shared with the witness.
Is it like that his voice is too meek? Its voice is too meek. It's almost like he's asking me a question. It doesn't have uptalk, or he doesn't have other sorts of things, but it's almost like he's asking me a question because of the lack of power in his delivery or his tonality. Yeah. Yeah,
And in response, she makes the search, which is entirely supported by all the credible forensic evidence. If Mr. Green is going to be a witness in front of the jury, in light of the fact that he has no methodology and he's wrong on the science, in addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense, he should have to stand behind those claims under oath. And so I'm asking for a Lanigan hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right. Thank you. Mr. Lessing?
The Boston accent probably is not helping. That's probably a significant factor in this, yeah. I think I don't like the Boston accent very much.
May it please the court.
What is with this guy's hair?
He is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search of House Long to die in the cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline.
Sounds defeated? Yeah, maybe. Thank you, Rosemary J., for the super chat. Very appreciated.
Testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology.
Okay, so this guy's got power.
Your Honor sat, obviously, and presided over that trial. Your Honor did not issue, after his testimony, any limiting or curative instructions
Yeah.
with regard to either his qualifications or methodology, nor did the prosecution, after his testimony, stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established, again, without objection. And
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detail than what happened in the first trial. In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in their motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to...
All right, I forgive this lawyer for his hair. His delivery is good enough that I forgive him for his hair. He can have a slightly weird hairstyle. He needs to get some hair straightener or something, but that's fixable. But you know, he's got passion and delivery. He's got vocal intonation. I like this. Okay, he's forgiven for his hairdo.
5 other areas of data forensics, and there's just this challenge to one aspect of his whole testimony and opinions. I have provided Your Honor with 2 exhibits demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs. And I would like to, Your Honor, use those in a moment. The Commonwealth, in its oral argument, said 10 times just now that there's no methodology and that Mr. Green does not articulate a methodology. That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor. While Mr. Brennan challenges the methodology, none of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenge the methodology. As a matter of fact, in their 2 reports, neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now. Exhibit 1
Yeah, you tell him.
is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde You look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step one in the methodology that everybody agrees to, everybody agrees that occurred. Number two, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint, that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Green has hurled several accusations without a...
I was just checking my behind-the-scenes stats here, and I saw that the video I posted for the Trump press conference was lit is #1 right now of my last 10 videos. So it's doing really well. So people liked it. Exciting. Plus, it had a really high comment rate, which was nice. 174 comments. It's pretty good for my channel. So yeah, people seem to like the Trump press conference excerpt. Excellent. Good news for me. More Trump press conferences in our future, baby. I think that's what's going to happen now. Turning back.
Basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Cellebrite UFED, a tool of Cellebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every...
People also really liked the video that I did where the federal judge defies Trump on pardons. I gained like 270 subscribers, which is really good, like for that one video. So if we can find more videos like that, if we can figure out what the commonality is, federal judge defies Trump on pardons. Trump, Jan 6 pardons the controversy, and then like judge defies Trump and refuses to dismiss with prejudice. So the federal judge defying Trump was very, very good for my channel. So we need more stuff like that. Yeah, we need more stuff like that, right? We need to figure out what we need to do is figure out the commonalities. So people seem to like the Trump stuff, and they apparently like it when I cover people defying Trump or like going against Trump and like getting smacked around. So that's the kind of content that looks like that's popular. So I'd like to do more of that stuff. Yeah. Do I think any of the Trump stuff could mess with the algorithm? I mean, it will change things to be sure, but more subscribers is good. More views is good. So I'd like to figure out how to give the people what they want. I lost like 35 subscribers. With birthright citizenship analysis. It's interesting. We need to take a look at this back end some more and figure out what we need to do.
Every case, without exception, is that the law enforcement sends the raw image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is value, and that leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffin's very long December 2024 report, which is Exhibit 1 to the Commonwealth's motion on page 3, and I'm going to read it verbatim. This value is talking. Here's the key point. However, this requires authentication of the original hash value, which is not possible with Gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all a fancy camouflage way of saying, Mr. Whiffin saying, I can't validate this hash value because of the way Trooper Guarino processed it. Do it, Mr. Guarino, Trooper Guarino, the right way when he got it. And why is this of concern? Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Guarino used the Celebrite UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Green had to ask for
the source is buffering. The feed is fundamentally buffering. It's not YouTube.
Trooper Guarino
it's the feed. Why is the feed buffering? I don't know.
Of the hash value. He used Gray key, which was a mistake, because Gray key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full extraction. Finally, after the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Green that is coming up out of thin air with these issues. This is the job of a data forensic person, and the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, Mr. Whiffin concedes it on page 3 of his report. That starts, and I'm going to get to it, all the concerns now about the data and deletions. But that's the foundation for it, and it wasn't caused by the defense. It was caused by Trooper Guarino, who didn't do this properly. And with regard to the methodology, I want to go back to Exhibit 1. So, importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffin, Ms. Hyde, and Mr. Bean all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each examiner saves the image to their lab storage system. Some use computer
Thank you,
servers,
DS, for the 5 gift memberships.
Storage. And 4, the methodology, you then process the data with appropriate tools. Nobody disputes that Celebrite Physical Analyzer and Magnet Forensic Axiom are 2 of the many tools that are available to use. There's a dotted line that I've put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5. And 1 through 4 is usually all one needs to do as a data forensic examiner. But Mr. Green went on to do more. Number 5, further processing of data as warranted, and he explains why it's warranted here, with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap, Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So, interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used 2 forensic tools. He only used Cellebrite Physical Analyzer and his own software, ArtX. That's it. What I'd like to, Your Honor, is ask if I could, please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
Okay.
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used, and how insufficient Mr. Whiffen and Mr. Garino are. So, if you look at the left-hand column on Mr. Green, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Green. You see 6 tools used by Ms. Hyde in May of 2023. Many of her tools exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Cellebrite Physical Analyzer. And then Mr. Garino, Trooper Garino, used 2 tools. But here's what's really important and I think remarkable that springs from this chart. Mr. Green did more, had a more encompassing and comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. And Mr. Green makes that very, very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Daubert Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on lines 14, the question. And what, if anything, did you find with regard to the web history artifacts? Answer, and this is Mr. Whiffen. So the 2/27/40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 2/27/40. And I did some testing on this and discovered the reason why 2/27/40 was actually listed in the database, even though that's not the time. Here's the key, in my opinion, that the search was conducted. So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that that search and that record that everybody saw at the time of trial, at 2/27/40, House Loan to Die in the Cold, Mr. Green says it means what it says. The search occurred at that time. Now, the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it, it's in there. Ms. Hyde said, I see it. It's not only in there in Cellbrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 2/27/40. That's the opinion that's disputed. So in fairness to the issue and accuracy, those witnesses diverted at the end as to whether what that timestamp showed, 2/27/40 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact and that Mr. Green doesn't have any fact. Well, Mr. Green's got a lot of facts, and he also, of course, has an opinion. So what we have from these two demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Green put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen in his 40-plus page report of December 24, nor Ms. Hyde in her December 24 4-page report, neither one of them say Mr. Green's doesn't have a methodology. They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute. And that is not appropriate. It's got to be your expert. And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology. What is also important is what has happened since the trial. And what I want to do is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Green has 25 years of experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old. there can be no dispute, and I think that's why the Commonwealth didn't really say anything about it, is because if you lay down Mr. Green's experience next to Mr. Whiffen, Mr. Green testified 23 times as a qualified digital forensic expert in 7 different states. Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience. Here's another very important point, certifications. Mr. Green lists 3 certifications. He lists an enormous amount of constant updating, and I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep updated because the computers change so much, so that's why you see such a great listing of Mr. Green in terms of his training in certificates, etc. However, if you compare Mr. Whiffen's qualifications to Mr. Green, and I'm again going to use Mr. Whiffen's own words with regard to his qualifications on his June 7th, this is again Exhibit 2 to our opposition, his June 17th trial testimony, page 1-6. Question, and this is a question from Mr. Lau. Now, with regard to your education in this area, what, if any, certifications do you have? Answer, no specific certifications. I've done the Celebrite coursework since joining Celebrite, but other than the 3-week course in Ottawa, and then again the 2-week course in Ottawa, those are police training things when he's a policeman. I don't have the SANS training or any of that kind of training certifications. Now, I am not here today to challenge Mr. Whiffen's qualifications. But how could it possibly be asserted that Mr. Green's not qualified if these are the qualifications of Mr. Whiffen? With regard to what has changed since the first trial, and I think this is incredibly important with regard to the methodology inquiry of Your Honor. I went through on Exhibit 1 the methodology that everybody agrees to. But the court doesn't have to take my word for it on this demonstrative exhibit because Ms. Hyde gives the best explication of the methodology that Mr. Green used because she used the same one before trial and at trial, but she's now narrowed it for purposes of a report, and I'm going to state and show exactly how. So Exhibit 4 to our opposition, Your Honor, is the May 2023 Digital Forensics Analysis Report of Jessica Hyde. And in that report, on page 3, she talks about, under forensic analysis, that she used, it's the exact same methodology.
What are you, I thought you said Exhibit 4. Exhibit 4 is a transcript. It's a transcript of Ms. Hyde, but it's not a report.
Okay, my fault, we have different numbering, but I'll go to the transcript. I'm going to go to the transcript with regard to it. So
I'm happy to look at the report if that's what you're referencing.
I'm
Where
going to
do I
go to the
find
report
it?
next, but if Your Honor's already at the, I can do it either way. If Your Honor is at the transcript, I'll go to the transcript right now. This is the June 14th transcript, Your Honor, of Jessica Hyde?
Yes.
Thank you. So, we're just, and please keep in mind that in Mr. Hyde's 2024 report, that Mr. Whiffen's report that is now before you, Mr. Whiffen only used, in his analysis now, Celebrite Physical Analyzer and Ardex, his own tool. He only used 2 tools. Ms. Hyde, in her 2024 report, which I will get to, is now down to just using 1 tool, Celebrite Physical Analyzer, because she states that's the only one I was asked to look at. So the Commonwealth went and narrowed the request of Ms. Hyde to just Celebrite Physical Analyzer. And what is going on here? It's very obvious. the Commonwealth is ignoring in its 2024 December reports all the other tools. Even though those tools show this timestamp of 2/27/40 still, at that time, they now just ignore it and go to the Cellebrite physical analyzer, that it's undisputed that Cellebrite went back and changed it in the middle of the first trial with regard to one physical analyzer program, and then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom, that Ms. Hyde used before, still shows the timestamp. It's undisputed that that's the case. And it's undisputed, because they don't contest it, that Mr. Green went and looked at it in Belkasoft, Sanderson. He did a manual, he did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor, I am looking at, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Green says. That's what Ms. Hyde did the first time, but now all of a sudden she's down to just one tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay.
Line 4. Question, again, of Mr. Lally. Now, with reference to the tools that you use that you just went through, are those fairly common tools? Are those tools that are commonly used within your industry? Answer, yes. And what are those tools that she talks about above? Starts on page 1-2. Cellebrite Physical Analyzer. Magnet Axiom. Artex. iLeap, and I later used Sanderson Forensic SQLite. Those are 4 of the tools that Mr. Green used, and he used more. So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. It gets better for the defense. Next question, line 15. So different forensic tools, question, and why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools, that they can only support so many applications, so they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Next page. Question, and with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Cellebrite, to Axiom, to Artex, etc., is that something you typically do as far as your normal process of documenting a forensic analysis? Answer. Yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent. And down below, he asked, can you explain the interplay of these tools in analysis? And her answer is strikingly the same as Mr. Green in his affidavit and in our opposition. Her answer, the Sanderson's tool, which Mr. Green and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Mr. Whiffen didn't use the Sanderson tool. So here we have Ms. Hyde, and in her report of 5/23/2024, her first report, and I'm going to get to her report here, She basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 22740 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees in its opinion issue in that regard. So now let's come to where we are for this motion and what was submitted by the Commonwealth. And I want to first
coffee is good.
the report of Ms. Hyde now.
Coffee is awesome. All right.
It's Exhibit 4.
I will be right back.
Commonwealth's
Talk amongst yourselves.
motion. And it's entitled Digital Forensics Analysis Report. And there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Green, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Cellebrite Physical Analyzer, and it's gone. The search is gone, right? And we know why it's gone, because Cellebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Cellebrite Physical Analyzer? We don't know the answer. All that is stated is a bald conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools, where it still appears. It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Cellebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Cellebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Cellebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Cellebrite just went back and for some reason deleted it, she says under the chart, while manual analysis of the database still shows a 22740 AMET timestamp, the determination in prior analyses and from Cellebrite is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis, and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Cellebrite Physical Analyzer.
So are you telling me that we should have a hearing?
Your Honor, there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert, because experts, almost by definition on each side, disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools...
All right, what did I miss, chat?
They agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Green's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? Everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Green did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the NB postulate. And the NB postulate is, why are people using different tools, etc.? Is because nobody has the source code for the Apple phones. So you use these tools to try to help interpret what these source codes mean. And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would an evidentiary hearing do? We're just going to come in and have witnesses talk about their difference of opinion? That's not what a Daubert is for. There's no basis for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Daubert hearings. I've never...
You love me despite the fact I piss you off?
An evidentiary hearing.
Well, that sounds like the making of a pretty good relationship, Aya.
Methodology. So what is it
that sounds like a making of a good relationship.
To raise questions? And again, I said data forensic examiners are just like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's what digital forensic examiners do, and that's what Mr. Green did. So there's great criticism of Mr. Green from doing what
they can't resist me.
For a digital forensic
they can't resist me because they're too attracted to my brain and the thinking and the intelligent stuff.
The Commonwealth now myopically go down to just one tool.
They may not like what I say.
What did Mr. Green say?
But they know I'm thinking.
That caused him to say, I think it strongly suggests that there's been manipulation here. He used the fact that there's no hash value for the data. That's conceded. And when there's an issue over hash value, every single digital forensic expert is going to raise concerns.
When you say, as we know at times I get lost, yeah, that's an interesting...
Who did that? Secondly,
we'll mute this for a second while we're just talking about this. You can read the closed caption. That's an interesting thing because it's like you don't know how much people know when they're watching your channel, because we've got a lot of longtime supporters, a lot of longtime people here who have heard a lot of these concepts, and also some new people. So I was experimenting the phrase with "as you know" or "as you might know" as a sort of a way to sort of bridge that gap, right? It's like, well, as some of you might know this thing, and then I explain the thing anyway. So it's sort of like, for the people who have heard it before, they don't feel insulted because they don't think I'm an idiot. They don't think I think they're an idiot. But for the people who haven't heard it before, they get to hear the thing. So I thought it was a nice bridge phrase, you know, to be like, okay, we're going to discuss something like, for example, 1983. We're going to discuss something like qualified immunity. So it's like, okay, some people have probably never heard this concept before. They have no idea what the hell what I'm talking about. Some people have heard me talk about qualified immunity about a lot, right? So it's like, how do I reconcile these twin problems? So it's like, okay, what I could say is something like, well, as some of you well know, like qualified immunity is a concept that gives officers immunity unless you can establish that it's a clearly established violation of law and that is clearly established, right? So it's like, it was my solution to find a nice bridge phrase, but a couple people objected to it, and I saw some people in the comments objecting to it. It's like, I don't know this, I'm just a layman. And I'm like, okay, so maybe the bridge phrase is not doing what I wanted it to do. But well, the hunt goes on to reconcile all these problems at once. Yeah.
He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there's also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics as spontaneous, and he doesn't cite any. Maybe it's because the search didn't load. Maybe it's because there was bad connectivity at where this search occurred. Well, that's interesting because a harder thing to load, the image that came up with food, did load. So you got to have stronger connectivity to get an image that dense. So what Mr. Green simply points out is that doesn't make any sense either. That is the essence of Mr. Green's affidavit. And Your Honor, just to be clear, when we sent in the second affidavit of Mr. Green, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, et cetera, et cetera.
Yeah,
So
Cosmic Ray. I thought about mentioning it, and then I decided against it.
And it's
I thought about saying it, but it's like, oh no, that seems too nerdy.
I have
It's like there's no such thing as spontaneous deletion of data. I'm like, technically there is.
Not say it's a supplemental.
Then you had to go and say it, Ty, and so now I have to say it too. Yeah, it's like the Cosmic Ray thing. That thought definitely passed through my head as he was saying that. I was like, yeah, I'll let it slide.
Y2, and it's a simple explanation. One supersedes the other. So, Your Honor, in terms of, and this will be the concluding part of my
The
remarks.
chimera meaning in biology?
In terms of the allegation that Mr. Green relies upon,
A chimera is a person who has two sets of DNA.
and he relies upon
Typically, it's because they absorb their own twin
and
in the womb.
It is just remarkable that that's the basis for his expertise. Mr. Green makes very clear that he did his own analysis. He used the tools himself. But here's why he called Cellebrite. At the time of trial, Cellebrite had two versions of physical analyzer on the market at the same time. One physical analyzer 7 showed the 22740 timestamp. It showed it, and it showed it in a deleted state. But the recent one, the one that Cellebrite updated 1 week before trial, didn't have it. So that was the Insights, spelled oddly, INSYETES. That didn't have it. So Mr. Green did what any good digital forensic person would do. He called up support and said,
Is microchironism where a mother will have some of her child's DNA for a while? I didn't know that one. So that one's new. That one's new biological facts.
The NIST standards.
The one that kind of blew my mind was the people who have both XX and XY.
Green's affidavit says
I don't know
that
how common that is. It's not very often, but
multiple tools.
it's like I read an article one time. It's like, oh, there's some incidents where people have both XX and XY chromosomes on like the same time. I'm like, that's an interesting dynamic.
And relying upon them, that is the proper methodology. So Mr. Green did that to corroborate and get explanation for what he found.
The other one that sort of blows my mind is the people with just one X.
Here is what is before.
It's like, how's that happen?
Pertinent.
Biologically, how's that happen? That your chromosomes are just X, just one X.
The inquiry.
I'm like, okay, well, that's interesting.
Polk, which
Biology's
Your Honor
weird.
cited in your decision on Dr. Russell, it comes down to, is Mr. Green qualified? There's not even a contest. Second, is his methodology reliable? And Your Honor, those are the only two subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now Mr. Brennan suggests bringing in Mr. Whiffen. I've never heard of that happening in a Daubert hearing, where one party challenges the witness of the other and then says, and oh, by the way, I want to bring in my witness to show. That never happens in Daubert. It's the person who...
I wouldn't say never.
Well, let me take that back. Good point. I won't say never. It is so unusual to have that happen under these circumstances. And this is the key, Your Honor.
X is going to give it to you.
We have a hearing.
Nice, Michael. 1 point for making me laugh.
And reliable if all of the witnesses agree what the methodology is. So, Your Honor,
I wonder if there's anyone who just has a single Y chromosome.
Urge the court.
Again, how would that happen? Who knows?
The motion
But biology's weird.
to exclude Mr. Green on one of 6 data forensic issues. He's going to be testifying, obviously, at this trial. And I would urge Your Honor to...
I bet you there is. I bet you there's someone who just has a Y chromosome. I bet you it's happened. Biology's weird.
Everything Your Honor needs to perform the gatekeeping function. And again, it's almost all undisputed with exception of one thing, and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you, Your Honor.
Okay. Any follow-up, Mr. Brennan?
I do. A little bit of knowledge of forensic data analysis can be dangerous. So when you hear representation...
Oh, says you. Says you. That is like an unintentional cell phone statement. A little knowledge of digital forensics can be dangerous, says the lawyer. Yeah, I don't know, ma'am. I don't know. I don't know, ma'am.
Arguments that Mr. Whiffen's opinion that there may have been a connectivity issue is undermined because there was a picture of food which is suggested through a application search. Misunderstands the basic premise that that's a cache picture. And that is
a cache
meant
picture?
for the user of a phone, for the user experience.
A cache picture?
Cached items that are available without connection that register and come up quicker from a different...
Isn't cache the more typical pronunciation? Someone's been saying it wrong all this time. I have a computer science degree. I was pretty sure it was cache, not cache. Lord.
Different source while it's waiting for a search to be conducted. It's simple, it can be explained, it's science, it's data. So when you take a little bit of data and you twist it because you misunderstand it or you want to advocate, that is the danger, and that's why it's best left to experts. What the defense apparently is mistaken about is that using a number of tools does not substitute for methodology. You can use one tool, you can use 30.
Yeah, it's French. Yeah, so as is typical in French, at least half the letters you don't pronounce. That's the key to French pronunciation. Half the letters aren't really there. Yep. That's French. Yep.
say on the timestamp that how long to die in the code occurred at 2:27 on that browser. That is the time that was opened. That window was opened.
I don't speak French, so I let my body do the talking. Yep, all right. Who knew that we'd be quoting girls aloud in today's stream? Yeah, there's something that's happening right now. That's good times.
At 2:27. But you can't just look at 8 different tools that are all going to say the timestamp is the same. You have to look into the data and into the databases, knowledge C, the history, and you have to determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear that 2:27 starts counting after 6 a.m. in the morning. And so that's what Mr. Green doesn't do. He doesn't engage in methodology at all. There's an agreed methodology. He doesn't use it. The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's an addition to her 2023 report. Mr. Green has not written a report. He has not provided data. He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls. And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from Mr. Green. There is none. Because if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him. There is no hashtag concern. And when the defense raises issues, postures, ideas, we never hear what the problem is. What is the hashtag value? Who manipulated it? And that is the MO. Blame anybody. Don't articulate who. Be like a ghost, evasive as possible, and then...
I mean, that's not really the right way around. And he doesn't really understand what he's talking about. Like, who manipulated the hashtag data or the hash data? Like, no, that's not what that means, right? A hash is a one-way function that takes data and provides a representation of that data such that if you change anything about the underlying data, the hash changes, usually pretty radically. And so it's a way to identify the underlying data and say this data is the same or not. So you don't manipulate the hash. You manipulate the underlying data, and hence the hash changes. You know? So that's the wrong way around. Yeah. Yeah. What kind of hash do I like? Shimmy, shimmy, shaw, shimmy, 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 shaw. That's my favorite hash. That's my favorite hash. Shimmy, shimmy, shaw, 256, baby. Yo, let's go.
It's not down, just posit a new theory. The government offers to bring in Jessica Hyde next week or in with him at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to.
The way I explained hash is correct, but felt awkward. Lol.
Policies that Mr. Green promotes in this case. And so we're happy to do it. We welcome it.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your
Okay.
Honor. Thank you for the opportunity.
Timing this.
The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right.
Yeah, I mean, a hashtag and a hash value are very different concepts. Yeah.
With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
No, you did actually keep it under 60 seconds. Good for him.
There are 4 exhibits that have been marked.
He actually did it. I appreciate that. I very much appreciate it. It's like, I'm going to talk for less than 60 seconds, and then he actually did it. How nice for a change. That's very much appreciated by me. You know, with this other lawyer, I want to cash him outside.
So it sounds a lot like it may just be a disagreement in opinions, but for the Commonwealth, I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an evidentiary hearing, and that I cannot decide this motion based on everything before me, I will let you know no later than Monday. Okay? So we'll keep next week, and I'll let you know. All right. So... And
this is like explaining Bitcoin to the family court judge during my divorce.
But we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery, and then we're going to talk a little bit about the motion to recover expert-related expenses.
Your Honor, we've been producing discovery as we've gone along to try to give the defense as much notice as we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or it's in the process of being turned over. There is one further report. We've retained Dr. Wilkes as a neurologist. I'm waiting for his report. He is away. And so my expectation is I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I'll have that report as well. My Rule 14 commitments are ongoing. They are involved. Enormous amount of time over the months has been spent trying to satisfy that I can.
Let's try another dad joke. If you don't understand hash values, then what you need to do is you need to pound the table. Yeah.
Account for all the discovery and make sure the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Okay. Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. There's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday. That's all included.
All right.
The analysis is done. The accident reconstruction is done. Mr. Crosby, who has expertise in bites and dog bites, his reports are in. Ms. Hyde and Mr. Whitman have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I have not reviewed. And
love you, Neo Dark.
that accounts for. We've been
Yeah.
through.
Your daughter's still applying to Clemson. Your daughter should apply to Clemson. Look at me. This is what you get from a quality Clemson education.
Provided. Made a very, very thorough accounting analysis with help of all of the information that isn't in those base numbers, and provided everything that I've come across as soon as I come across it.
All right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself. And so I've gone through the entire phone.
A 4.56 GPA. I would think that would do it.
Rule 14, but broad discovery. Pursuant to a protective order this morning to the defense, so they have anything that, from my perspective, from my experience, would be remotely important or interesting to them. Also, I've gone through, well beyond my obligation, emails of members of the District Attorney's Office, and that continues, and I have another production as well. I wouldn't call it Rule 14 because it's not necessarily statements of witnesses, but again, I've taken a very, very liberal and broad view of what I would potentially want if I was defending a case. And I've provided that again under seal today.
All right.
And so we do not have an official discovery order, but I'd like the defense to have their discovery to me 30 days after I complete mine, which will be next week.
Okay.
We filed, but I did not see on the docket, or we sent in, we did not file a motion for clarification, and Your Honor did not mention that. That's an important notice that we had sent in because I am greatly respecting the April 1st trial date, and there is work to be done. And so I would like to address that motion and clarify what appropriate.
1983 was the year right before 1984. I'm not sure about that one. I might have to double check that.
I'll need
To
some
double
time
check that
to
information.
review this, obviously.
But could be.
Okay. All right. That's great. So the Commonwealth expects to be ready for trial April 1st.
Yes, we do.
On April Fool's Day. Outstanding.
So now let's just
How appropriate.
take a look at.
Or as long as we're doing
if you
French,
will,
how
the
apropos.
Defendant's motion to recover expert-related expenses from the Commonwealth. Okay. I see there's a written opposition that I just received. We're not going to hear this motion today because I
don't know
didn't have
much
the-
about it, but there was at one point a sort of a language called law French. I don't know much about it except to the extent that I know it once existed. That's exciting. The law had its own separate language in French as a French derivative. Can you imagine, man? Holy shit.
Opposition, but one of the things that I'm hoping you can tell me before we hear this, all right, there are a couple of things. Let me just, in this motion, there's a footnote that references, so this motion from the Commonwealth was filed, from the defendant, was filed on January 23rd. So more than a week ago, and the motion, I believe, is a footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving. When will that, well, I'd like that filed next week so we can hear it next week.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all the discovery. And I think it would be premature for us to figure out exactly what the parameters of our motion to dismiss are until we know exactly what the Commonwealth is putting in front of us in terms of the second trial. But as soon as we get that, we think that we have the grounds to bring that motion relatively quickly thereafter.
So you expect to have everything to the defendants by Wednesday?
I do, and really what's missing is a report from a neurologist, a witness interview that is really inconsequential, and Ms. Hyde has a report regarding a phone. That's all that's really left for discovery, so that's all I can say.
Yeah, I don't know, man. A witness interview that's inconsequential. The lawyer in me, all the lawyer heard in me is this is the most important witness interview that's ever existed in the history of ever. That's what I heard. Holy shit, dude. Come on. Oh, come on.
All right, so if you get it by Wednesday, we're here Thursday and Friday. I'd really like to see something by Friday. You've obviously been working on it, even if we end up having to do it in piecemeal.
We've been thinking about it, but we have not. I don't know what you mean by working on it. Yes, obviously we're working that direction, but Your Honor, there's no way for us to reasonably get that done by Friday. That's just there's so many other things that we're dealing with, including hearings like this that keep coming up over and over and over. I'm not. The court knows we don't drag our feet. As soon as we get something, we act on it. I just can't promise that we could get it done by Friday. We are working on it, and we're not.
So
there's no strategy for us waiting. I promise you.
Be prepared to discuss it next Friday. I will be looking for it very shortly thereafter, and we will have a hearing on it very shortly. time to respond.
Understood.
So we need to come up with a scheduling order, or I've got a scheduling order that we need to discuss. But regarding this motion, what I need to know before I hear the motion on the expert-related expenses is what sort of protocol you all worked out. Maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified? What the arrangements were? How this all was set into play, and why there was a violation?
I can certainly brief that for the court. We addressed it pretty significantly in our motion in terms of the conversations that were had, the expectations that we had, the protocol in terms of getting our expert out there from Arizona.
No, what the agreement was, right? People don't just show up for the other side's expert. I just need to know what steps, what the agreement was for your expert to view this on that date.
Most of this was reduced to email. I think it'd be
so
probably
put
a
it,
little bit more accurate for me to just go back and file a supplemental brief.
yeah, so I need all that information from such egregious conduct.
Sure. Okay. I'll submit that won't take very long at all.
Because then we'll address this next week.
Okay, that's fine.
All right. If we do not have an evidentiary Daubert hearing, do we need both days? Or does it make sense to schedule everything for Thursday? What's the Commonwealth's position on that?
Absent that, I don't think there are a lot of matters before the court. The motion for clarification should take probably less than 20 minutes.
Okay.
And the motion for fees is a very simple discussion. So I don't think there's any way we'd need 2 days unless there is actually an evidentiary hearing, and then it'll take some time.
Okay. What do you say, Mr. Jackson? You're nodding?
I agree. I think if there's an evidentiary hearing, it's going to take multiple days. If there's not, I think we can pack everything into Thursday.
All right, because I don't want to waste everybody's time. I want us to get this case moving.
Of course.
So you will then file that motion to dismiss the following Monday or Tuesday, and we need to set it up for a hearing, if you are indeed filing a motion to dismiss.
I'm sorry. The motion to dismiss on which Monday or Tuesday?
After we meet next week.
Following week.
Yes. I just want to get a scheduling order going, so I need some of these dates, because we're going to need to schedule a hearing on that. I do not anticipate an evidentiary hearing on that, but I expect it will take time. All right, so the Commonwealth will have all of its discovery to you, it expects, by Wednesday the 5th?
That's correct.
Okay. We'll be back here at the end of next week. After you have that discovery, I can give you until February 11th, the following Tuesday, to file a motion to dismiss. And Commonwealth, I'll give you until the 14th to file an opposition to the motion to dismiss. And let's hear it the following week. We're also going to have to, does the defense anticipate any evidentiary motions?
Yes, but I can't tell you exactly what those are, but in an abundance of caution, given the fact that we're expecting new information from the Commonwealth, I think the court can safely say yes.
So February 21st, and I'll put this in writing, filing of all evidentiary motions. That can be an out-of-court date unless we choose that day to hear the motion to dismiss. Why don't we figure out what's your availability the week of the 17th? The 20th is actually the best day that week for us.
Your Honor, that is, that week is school vacation week.
Both Mr. Jackson and I have young children, but one of us, I think, could probably be here on the 18th.
On the 18th?
Right.
Yes, Your Honor.
Okay. Well, all right, so I'd like you to get me, can the Commonwealth get me the opposition by midday on the 14th? So I'll have it to review over the weekend. I know you haven't seen it, so it's hard to figure out how much time you need. Is the Commonwealth available on the 18th?
I'm available anytime.
Okay.
I mean, we'll put all our effort into it. If we have a problem, we could let the court know.
Okay.
We'll do our best.
Okay. All right. Okay, so the 14th will be an out-of-court filing date. The 11th, an out-of-court filing date. So the motion to dismiss hearing will be on Tuesday, the 18th. Filing of all evidentiary motions will be the 21st. And that will be an out-of-court date. We will do the hearing on all evidentiary motions March 4th and or 5th. I'd like you to block off both days at this point. And if we don't need them, we'll try and, I don't want everybody coming in for just one motion. I know how much work you all have to do to get ready for trial. There's a lot of work I need to do to get rid of trial, but I'd like you to block off those 2 days because we can't have motions to suppress going on and on past that date. I'm going to need some time to review them and write them, so. All right. Can you all come back in on March 7th? You'll file all motions in limine. We'll have a final trial conference. And then we'll have to set up a date for what I anticipate will be at least a day, maybe two, because it was last time on motions in limine. All right, so March 7th will be an in-court date. And file all motions in limine. And at that time, I want you to tell me how long you expect your motions in limine to take.
Your Honor, do you want those filed by the 7th? All motions in limine filed by that hearing date, the 7th?
Yes.
The transcript having a little problem with the phrase in limine, I see.
On the 18th, which only gives me 2 weeks to decide them.
Shouldn't take that long, I wouldn't think. Lol.
Because we're starting the trial on April 1st. Jury Commissioner's Office has been fantastic.
Starting the trial on April
about
1st is
getting
just
us
begging the defense to start
many
their
jurors
opening
as
with
possible.
this entire trial is a joke.
And we'll talk about impanelment, obviously, a little bit later.
That just seems like.
All right.
I'm not sure you want to set the defense up for that by having it start on April 1st.
All right. Anything else we need to discuss today?
Not on behalf of Ms. Reed, thank you.
No, thank you.
Okay. All right. Thank you all.
All right. Well, that was exciting and fun. All right. Should we start a separate stream to do the Crumbly hearing, or should we just like... Let's see. Okay. So that went for an hour.
Unremember this.
All right. So what is the logical thing to do here in terms of this? Let's start a new stream. I think that makes more logical sense. And we'll send people over there. Yeah, I think it makes more logical sense to keep things organized by creating a new stream. So we'll do that. Give me just a moment to do that, and then I will forward you. I'll forward you. Hold on. Calm down. Okay, let's see. Crumbly. Okay. This is a motion for a new hearing or moot trial, I guess. Jennifer Crumbly demands new trial. Okay. Motion hearing. That will work as a title. Okay, I'd like to do that. I'd like to do that. Subscribers, you can be a subscriber of any duration. Slow mode of 15 seconds will be fine. Public, it's going to go public right away. And schedule and schedule and schedule. Great. Now I need to set up the redirect. Okay. And do that. Okay, go here. Save it. Fantastic. All right, the redirect is up and saved. So we are going to go ahead and do a new stream effective immediately. So you should hopefully get redirected. And if not, check your feed. It will be there, hopefully, and all that good stuff. All right, fun. I will see you over there in just a second. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my friends, for now, and goodbye.